So thank you all for being here today. I'm Richard Liebowitz. I am a photographer, photojournalist, and copyright lawyer. So I used to photograph a lot in New York for a lot of the local newspapers around New York, traveling with many photojournalists. And I would travel with my fellow peers, and they would always tell me, listen, today this outlet ripped me off today, or this media outlet just stole my image. And I would tell them, you know, what'd you do about it? So they would say, I would contact the editor, and either they would say, it's fair use, or, you know, I'll get back to you later, or, you know, or they would never get a response at all. How many of you guys have had that experience before? Show of hands. Okay. So what I did was I decided to go to law school to help my fellow friends and peers and photographers with this big problem of copyright infringement, because there was this brick wall between photographers and outlets that were stealing where they would never get compensated. So my friends 2 years later gave me all the screenshots of all their infringements, and now those outlets got sued 2 years later. So their wish came true that they got sued instead of just paying up. So today I'm going to be talking about a few cases, and I want this to be a little bit interactive because I want to get your thoughts on if you were a jury and if you were in front of lawyers and if this was a real court case, what your feedback would be on the particular case. So a little bit about me. As I said, you know, copyright photojournalist and copyright lawyer. I'm also I published a book called Apprentice: Lessons Learned on the Front Lines of Life, where I travel with an award-winning photojournalist and document my experiences and life lessons. I'm also an active member of the Copyright Society of the USA, where we talk a lot about these issues that face photographers every day, from copyright to First Amendment. Really fascinating how many issues actually affect photographers in today's age. And I'm also a member of the New York Press Photographers Association, which is a great organization here in New York that has a lot of meetings on different issues that affect photographers in the media business. So I want to jump in and talk about, because there's a lot of myths out there on when your copyright is protected. So when is it protected? So the copyright exists from the moment the work is formed. It automatically belongs to you. And it's different from actually getting it registered with the Copyright Office, where you have to actually go to the Library of Congress. I do encourage that everyone registers their stuff with the Copyright Office. Now, show of hands, how many of you guys register your work with the Copyright Office? Okay. So it's very important because you get what they call statutory damages if there's an infringement. And it's very important because those damages are very high. You could potentially get up to $150,000 per work, which is very significant. When you're suing someone and they're looking at that high cap, they're afraid of the $150,000 as opposed to the actual damages, which may just be the licensing fee plus any profits. So it's very, very important. Now, the duration of your copyright is very important. A work created on or after January 1st, 1978, it's protected from the moment of its formation until 70 years after the author's death. So it's very, very significant how long the duration is. Now, how many of you guys know about works made for hire and what that means? Okay, so I'm going to briefly go over what work for hire means. Work for hire means a company or someone will hire you to actually hire you, and they own the work. So it's important that you understand that from the outset when you're negotiating a deal with a particular company, who owns it from the outset, so that if there's an infringement going in the future, who could sue for copyright infringement? Who owns the copyright? And this needs to be in writing. So how many of you guys do arrangements with companies to do photo shoots or whatnot? Okay. So it's very important at the outset that there's an understanding between you on who owns what, and it's very important that you have that. So works made for hire, the duration is 95 years from publication or 120 years from formation, whichever is shorter. Very important. Now, next thing that I recommend is, how many of you guys put watermarks on your photographs? Okay, very important. And how many of you guys use metadata in the photographs? Okay. So metadata is also a great tool to put the infringer on notice on who owns the work. Because in today's digital age, you could just right-click on the photograph and find out who owns the photograph. There's a copyright symbol in there. So today, the infringer can't say, oh, I didn't know who owns the copyright to the photograph, because they could just right-click on the photograph and find out who it is. So I recommend doing metadata and also putting these three things on the photograph. You have the C, or the abbreviation COPR, the year when the work was first created, and the name of the copyright owner. For example, 2019, Richard Liebowitz. You could put that on the right-hand corner or a clear watermark on there just to put the person on notice on who owns the work. It's very, very important. Okay, so as I said, put watermark on it or metadata. These are really great tools for photographers to make sure your work is protected. Now, as I said a little bit earlier, how important it is to register your work with the Copyright Office, because these are the remedies, and these are the numbers that you want to look at. So if your work is registered with the U.S. Copyright Office before the infringement occurs or within 3 months of first publication, you're entitled to statutory damages. So, and these are the numbers. For a non-willful infringement, damages range between $750,000 to $30,000 per work. And for a willful infringement, damages could go up to as high as $150,000 per work. So when you're suing an infringer, and I see it all the time when I'm suing, you know, the infringer's looking at, wow, I potentially could be liable for $150,000 per work. And there are cases out there that courts have awarded $150,000 for one work. You know, and that's for the very egregious, you know, infringement. You know, here we have a question here. Oh, yeah. Yes. So the question was basically, what does a publication mean? And that's a great question, because it's very important to know what publication versus not publication, unpublished means. And it leads me right to my second slide on what publication and unpublished means. So the Copyright Office wants to know whether you put your images out there. So this is what it means in legalese, and then I'm going to talk about what it really means in English. So publication is the distribution of copies or phonorecords of a work to the public by sale or other transfer of ownership, or by rental, lease, or lending. The offering to distribute copies to a group of persons for purposes of further distribution constitutes publication. Okay, so what does that mean in English? That means if you're offering the photograph to someone, that's considered published. So you have 3 months from when you do that to get these statutory damages. Or, for example, let's say it's published in a magazine or published in a newspaper. Within 3 months of when you do that, that's okay. Or, how many of you guys use social media today to showcase your work? Okay, very big. And I'm going to go over a little bit later in the presentation about the terms of service and what you sign up for when you actually post things on social media. Because there's a big myth out there, you know, who owns the copyright when you post things on Facebook or Twitter or Instagram? Do they own it? What are your rights? And I'm going to go through that a little bit later in the presentation. So when you're putting it on social media, when you first publish it, that's considered published as well. So it's important to, you know, jot these dates down so at the end of the 3 months, you could get everything registered with the Copyright Office within the 3 months. So that's publication. Everything else is considered unpublished. So for example, let's say you're photographing, you know, headshots, right? And you don't give it out to anyone. You could register it as unpublished before you give it out to anyone, because you didn't actually distribute it yet. So these are two things. This is very important to know, because when you're registering with the Copyright Office needs to distinguish. And if you get it incorrect, the defendant's going to say, "Oh, it was actually published as opposed to unpublished," and it's going to mess up the whole registration. And you may not get the $150,000 per image, and that's very significant when the side looks at those numbers. Okay. Now, it's also very important to know unpublished works, it must be registered before the infringement to get the statutory damages, not within 3 months. A lot of people get the impression, is it within 3 months of finding the infringement or within 3 months of the infringement? No, that's not accurate at all. It's within 3 months of when you first publish your images. So that's very important to know that difference, and that you build it into your workflow. What it is each time you're publishing your images, put it on a folder on your computer and label it by date and throw in all JPEGs into those folders, so that at the end of the 3 months you have everything all organized and you're not scrambling at the end of the 3 months to find which ones were published, which ones were unpublished. So very important. Now, the damages for if it's not registered with the Copyright Office, and believe me, if it's not registered with the Copyright Office, don't worry, because there's still remedies. You could still sue for copyright infringement, just the damages may be lower. So these are the remedies if it's not registered with the Copyright Office timely. So the actual damages, which is generally speaking the licensing fee, and any profits of the infringer that are attributable to the infringement. For example, if there's any advertising or sales, or I'll give you an example. About a year or so ago, I had two concert photographers and music photographers photograph the band Motley Crue. And next thing you know, the band and the merchandising company used the images on merchandise on their final tour. And it happened to be that my client was on a cruise in the Bahamas, and he found his image on a T-shirt, and he went up to the guy and said, "Where'd you get the T-shirt?" And he says, "Oh, I got it at the concert hall where Motley Crue had its final tour." And he was shocked. And he couldn't believe it that his images appeared on not only T-shirts, but mugs, keychains, and towels, and the whole 9 yards, selling for $50 at, Madison Square Garden or at the local concert hall in Denver. And he was shocked. But here, it's very interesting because look at the second point. You may be able to get the profits from the infringer if it's not registered. So in that particular case, what we did was we had to ask for all the profits from the sales of all the T-shirts and all the mugs and whatnot. And then you would have to have an expert come up on the stand and say, okay, how much of this was actually attributable to the use of the photographs? And when you're buying a T-shirt, right, at a concert hall, let's say Madison Square Garden, right, you're looking at the picture. You're looking at the picture on the T-shirt to see whether or not you want to buy it or not. That's what attracts the sales. So we needed to eventually have an expert go on the stand and have a jury and have 7 people in front evaluating and seeing how much money the actual photographers would actually be entitled to. So it's very, very fascinating. So, these are the remedies if it's not registered with the Copyright Office. Okay, the next thing that I want to go over is this very gray area and what everyone hears all the time, fair use. So I want to go into a little bit detail of what courts look at to determine whether a use is considered fair or not. So when you approach the infringer and the infringer says, we're using it under the fair use doctrine. Okay, so this is what courts or jury, let's say you were a jury and you were doing a copyright case. How many of you guys have been did jury duty before? Okay. And how many of you guys have been a jury on a copyright case? Okay. Or how many of you guys would like to be on a jury on a copyright case? Yeah, that's what everyone says. It would actually be fun. So these are 4 factors that a judge or a jury would have to evaluate to determine whether or not something's considered fair or not. So first is the purpose and character of the use, whether the use was commercial or non-commercial. Was this a company that was selling T-shirts? Were they selling advertising on the articles like a publisher? Or was it a nonprofit? Was it for educational purposes? Right? That's one factor that the court evaluates. The second is the nature of the copyrighted work. What is the work that you have here? What is it? Is it, a band or is it a portrait? Courts look at that as well. Third is the amount taken. So for example, let's say they're cropping the photograph out and it's not the whole photograph. Or for example, let's say it's 10 seconds of a 10-minute video and they use 10 seconds of that video. That's a third factor that the courts look at. And fourth is the effect of the use on the potential market. So for example, let's say you license the photograph to one newspaper, and next thing you know, another newspaper rips it off, right? Since you licensed it to one newspaper, it affected the market because you did license it to one newspaper, and why should that second newspaper get away with it? So these are the 4 factors that courts look at. And I want to go through now a few cases, and I want to get your evaluation of what you think the courts came back with on a decision. All right. So how many of you guys know about this case? It's called Carew versus Prince. How many of you guys know about who Richard Prince is? Okay. So Richard Prince is a famous appropriation artist. What he does is he looks for images and he changes it around and sells it for tens of thousands or millions of dollars. So this is a famous case where Patrick Carew, here's his photograph on the left, and Richard Prince, what he did was he took the image, right, and look at what he did. He just added blue dots to the eyes and the mouth and added a guitar, right? And he was selling this for tens of thousands of dollars. So now, what do you guys think on what the court, right, what the judge said evaluating those 4 factors that we talked about earlier? And I would say most specifically the amount taken. A show of hands of how many of you guys think that the outcome here was that this was considered an infringement? So think about it. Okay. About half? Okay. And how many of you guys think that the court found that this was considered fair use? Okay. Very few hands. Okay. So, drum roll please. The court found that this was considered fair use. And the court said that it was changed enough, looking at that factor of the amount changed, right, that this was changed enough, right, to make this considered fair use. And Richard Prince was free to continue selling, you know, his artwork for tens of thousands of dollars. So really fascinating. So it's looking at those four factors, you know. But if this eventually went to a jury, you know, it would be your decision on what you think based off of those four factors. Now, I want to turn to another case that's also very fascinating. How many of you guys have heard about this case, Rogers versus Coons? Okay. So R. Rogers, a famous photographer, took this photograph of this couple with dogs. And Jeff Koons, also a well-known artist, made a sculpture that's pretty similar, right? It was a couple with dogs, right, sitting on a bench. And Art Rogers saw the sculpture and said, hey, there's my photograph. You're infringing upon it. Even though it's a different medium, right? It's not a photograph. It's a sculpture. So Art Rogers sued Jeff Koons for copyright infringement and said, hey, you know, you're copying me. So a show of hands doing an evaluation of those four factors that we talked about earlier on the amount taken, the nature of the work. He was selling this for, you know, obviously commercial purposes. But weighing the factors, how many of you guys think that this was considered fair use by the court? Okay. Okay, and how many of you guys think that this was considered an infringement? Okay. So the court found that this was considered an infringement. So even though it was a different medium, right? And, you know, the court said that this was considered an infringement. So taking a look at both of these cases and saying, wow, you know, how could one court say that this is considered an fair use, and the Rogers versus Koons case that this is an infringement? You know, you could see that cases could come out so differently, you know? Say again? Yeah, it was a significant amount. I have to find out how much it was, but, you know, it was the Art Rogers ended up winning, you know, which is a really fascinating thing. But I want to see your analysis on this particular. Any show of hands if you were on a jury and what you would think, you know, what your thoughts were. What do you think? Go ahead.
I would want to know if this sculpture is being sold.
Yes, it was. Yeah, so the question was he wanted to know if this was being sold. Yes, it was being sold, so commercial purposes. Go ahead. Well, yeah, well, that's a good point, you know. But yeah, it's very fascinating. Go ahead.
So in other words, it's considered infringement because even though it's a different medium.
Yes.
Because of the dogs.
Yeah, well, the court evaluated everything. They looked at the, so the question was, you know, why the court found that there's infringing. So the court went through the analysis, those four factors of fair use, and said that this is similar enough that this was considered infringement, even though it was the same, it was a different medium.
So it is considered more original because of the theme of the dogs.
Yeah, well, that was probably, you know,
The other picture that was considered non-infringement, why wasn't it infringement? Because it was actually an original picture.
Yeah, well, listen, we have to go through the judge's mind and find out, and you'll have to read the decision. You could Google the decision online and go through what the court actually thought in terms of an evaluation process, but it's very fascinating. Go ahead.
I think what it is that the judge's opinion, not artists.
Okay, well,
Do they have an expert explain what it is that causes something to be derivative of what actually an artist does in order to create a work?
Yeah, so the question was whether there was an expert, and obviously what the judge's thoughts, whether they were an artist or not. But yeah, no, I mean, in terms of having an expert up there and evaluating, why this particular judge said this was considered fair use, and this was in New York, an artist capital of the world, to evaluate. But if this went to a jury, I would have an expert go on the stand, and the other side would have an expert witness go on the stand as well, and evaluate and say, hey, and both sides would argue, and if you were on the jury, you would have to make the decision on whether this is fair use. Now, I want to turn to one of my cases that ended up settling, but I want to get your thoughts on whether you think this would be considered fair use or not if you were on a jury. Okay, so this was a case called Clayton and Parada versus New York Gallery. So a gallery in New York City was selling this painting by an artist from France for $50,000. And what this artist did was combined two pieces of artwork. One of them was of Snoop Dogg on the left. That was a drawing. And then in the background was another artist. The name of the painting was Siblings Rivalry. But all the artist did was combine both the Snoop Dogg drawing and the Siblings Library painting and combined it into one. So the artist found that the painting was being sold in a gallery in New York City by this famous French artist, and he sued the artist, or I sued on his behalf, the artist and the gallery in New York City. And what they come back with, the other side were saying, oh, this is considered fair use. And I want to get your thoughts evaluating, looking at those four factors on what do you think? Do you think this was changed enough to be considered fair use? What does everyone think? What do you think? Okay, so he said that this was altered enough, or it could be considered, if it was changed enough, to be considered fair use. Anyone else? What do you think? No? Not changed enough? Okay, what do you think? Yeah. Anyone else? If you were on a jury and you were evaluating, and I was for the plaintiff and someone else was up there for the defendant evaluating, what your thoughts are? Go ahead. Okay. You think it's an infringement? It's Snoop? Okay. What do you think? Okay, so it was just two images that were combined and that the artist really didn't do anything to change it. Okay, so it'd be very interesting to see if this was taken all the way, what a jury or judge would find based off of those other two cases that one of them said that it was infringement and the other one said fair use. But this could happen to you. This could actually, if you're an artist or a photographer and your stuff is out there, you want to make sure your stuff is protected, because this artist actually happened to find these two pieces of artwork in one book. It was a big, thick book where there was pictures in there and artwork in there, and the artist just found, it was on two separate pages. One of them was in the beginning of the book, the other one was later in the book, but it was very, very interesting to see that this artist found these images and sold for a lot of money. So it's really interesting. Go ahead, I knew you had a question.
Is there something in the law that says how much something can be changed before it's considered a new entity?
Okay, so the question was, is there something in the law that says how much it needs to be changed to be considered a fair use? And no, there isn't anything. It's just, the amount taken, and the court's going to weigh how much is changed enough for it to be considered fair, and that's why there's a jury. That's why there's a jury to determine, is it changed enough? So it's really very, very fascinating. Go ahead.
What's your opinion?
Yeah, well, I in my opinion, representing the plaintiffs, is I believe that this is an infringement. That, how can an artist just, combine two things being, identical and just combine it and sell it for $50,000? So it's very, very fascinating.
You have changed your mind and been hired.
No, I'm a plaintiff's attorney. I'm a photographer myself. Go ahead.
Cases that were decided that you showed us earlier, were they both
Judge, yeah. So sometimes, yeah, exactly. So depending on the cases, you know, some of them could be ruled by one judge, and you want to hope that that particular judge is an artist, right? You know, or, you know, if it goes to a jury and you're picking a jury, and this is where, you know, tactics come in. You want to get a jury that's sympathetic to the artist, right? You're going to depose, you're going to ask them questions and say, you know, have you ever been an artist? You know, do you do paintings? Do you draw? You know, the other side is going to likely say, defendant, are you corporate friendly? Are you, you know, are you into business? You know, to try to be more favorable to your side. So it's very, very fascinating. Go ahead, question. Oh.
Say the artist is really conscientious and said, I want to do it the right way. What would they pay both artists a certain amount to buy it?
Okay, so the question was, let's say the artist was very conscientious and did want to actually create this painting, how would they go about doing it? So the proper tool is to go to both of the artists and said, hey, I want to create this painting that incorporates both of your artworks together and create, you know, my own. So they would have to contact the particular artist and then maybe negotiate something whereby if there was a sale of the painting, each side would get X amount of the money. And that's the proper tool to go about getting the proper permission. So it's very important. Now, I want to talk about another very interesting case before we get in. Okay, last question and then we'll go.
There is no precedent that says that it's wrong to say I'm going to take this person's work and this person's work and scotch tape them together like a little kid would, and now it's mine.
Yeah, well, that's, you know, appropriation artists, right, like Richard Prince, they make all their money off of doing that, you know? So they're using the law to their advantage. I want to talk about quickly about another interesting case, one of my cases, where I had a photographer that shot this wedding. It was actually his wedding, it was a couple. And next thing you know, look what happened. Kate Spade used the image in a picture frame and cropped out the groom. And here it is. Now just the bride in a white dress, you know, in the paper frame of the frame, selling it in Macy's, in Bloomingdale's, Dillard's, all around the country. So what I had to do is go around to the department stores and take a look and see where this image appeared. So it was in the paper frame, and Kate Spade didn't get permission from the photographer to use the image on there. And here it is in Macy's. So what I did was, from a plaintiff side, since I filed the lawsuit, and if this would eventually got to a jury, I interviewed the people looking at the picture frame and saying, wow, you know, do you like that particular photograph in that picture frame? You know, so I'm trying to get them to say, wow, the picture looks great. I'm going to buy the picture frame for $150. Because if you were a jury, I would have that up on the stand and showing and having a video, because this is where that prong where I talked about earlier, the actual damages, right, the profits attributable to the use of the infringement, what percentage of the sales of the picture frame were attributable to the use of the photograph in there. Obviously, Kate Spade is looking for a nice, great picture, right, a beautiful picture to put in the frame, or else they won't get sales, right? That's all about marketing, right? If there was a picture of some, you know, something, you know, not as attractive as that, maybe the sales wouldn't be as high. So really, really interesting, you know, case, and this ended up settling because I sued everyone in the chain of line, Macy's, Dillard's, and everyone in between, and they didn't want to get involved because they would have to go through all their revenues and everything like that. But, you know, as a plaintiff, you want to try to sue as many people as possible because, you know, you get more money that way. So it's really fascinating. Now, quickly, I want to go through social media and copyright and how important and what you guys are signing up for when you are signing up for these social media. So how many of you guys are on social media? Just a show of hands. Okay, so almost all of you guys are on there. Okay, and how many of you actually read the fine print when you sign up in the 8-point font, in italicized, right? Basically no one, right? I mean, it's like when you're buying a car or you're, you know, getting a mortgage. It's a small fine print that people never read at all. But what I want to go through today is what you actually are signing up for when you sign up for the terms of service. Okay, so for these Facebook, Twitter, Instagram, you still own the copyright but read the terms of service to each website to see about the certain licenses that you grant when you post on social media. So, this is what the small terms of service says on Facebook. So you own all the content and information you post on Facebook, and you could control how it is shared through your privacy and application settings. In addition, for content that is covered by intellectual property rights like photos and videos, you specifically give us the following permission. Subject to your privacy and application settings, you grant us a non-exclusive, transferable, sub-licensable, royalty-free, worldwide license to use any IP content that you post on or connection with Facebook. This IP license ends when you delete your IP content or your account, unless your content has been shared with others and they have not deleted it. Okay, so what does that mean in English? Right? You grant Facebook a license to use your work. That does not mean that other people could use your work, but Facebook, the company, could actually take your photographs that you post and use it. Let's say for, editorial or commercial use. Or how many of you guys have been seeing commercials for Facebook over the past couple of years to promote Facebook, which is very interesting what they're doing. When you post something, you're granting them the license. So be careful, what are the odds of actually Facebook using it, but those are the terms of Facebook of when you sign up. Now, Twitter has very similar, terms of service. You grant a worldwide, non-exclusive, royalty-free license to use, copy, reproduce, process, adapt, modify, publish, transmit, display, and distribute such content and any and all media or distribution methods now or later developed. So, also very fascinating. So you're granting Twitter, the company, a license to use your work. That does not mean that media outlets could go onto social media and get your photographs on there and just credit Facebook or just credit Twitter. That doesn't mean that they're allowed to do that. That happens all the time and they're infringing upon your work. But this grants the company. And as all companies, they're trying to limit liability, right? They don't want to get sued for any IP content. So in the very small print, when you sign up, this is what you're granting them. Now, Instagram. How many of you guys use Instagram? Very big today. Okay. Almost everyone uses Instagram. Very big. So Instagram does not claim ownership of any content that you post on or through the service. Instead, here it is again. You hereby grant to Instagram a non-exclusive, fully paid, royalty-free, transferable, sub-licensable, worldwide license to use your content that you post on or through this service. So you're granting Instagram a license to use your photographs or your video. And this applies to everything: photos, videos, text, digital art, anything IP related. Go ahead, question. Yes. Okay. So what that means is, let's say, so the question was, what does transferable and sub-licensable mean? Okay. So that means, let's say, for example, Instagram gets sold to another company. This license transfers to that new company. Yes. And sub-licensable means that they could actually license the photograph to someone else. So it's very interesting. I don't think they do that, but this license does grant them to sub-license to someone else, let's say an agency or whatnot. So it's very, very fascinating. Now, go ahead, question.
Do they need to give you photo credit?
No, there's no, they don't have to give you photo credit. You grant them a license. It's not in there that they have to give you permission or anything or any credit or whatnot on there. So. Now, how many of you guys use Pinterest? Okay, Pinterest is a little bit different, because look at what Pinterest says. Pinterest, you grant Pinterest and our users a non-exclusive, royalty-free, transferable, sub-licensable, royalty-free license to use, store, display, or reproduce the work. So that means that other users, so this is different than Facebook, right, that it doesn't say it's users, but it's very fascinating how, Pinterest, not that many people use it, but this is their business model, allowing others to use your content. So it's very, very fascinating. How many of you guys have any questions related to social media and any of these terms of service? Because it's important that you guys know. Okay, so the question is how to remove that license and what you do. Yes. So if you take a look at Facebook, when you delete your content off of Facebook, then the license ends. Then they can't use your content. However, if it's been shared by others and they haven't deleted it, then the license says that it continues. So how many of you guys know about sharing and about embedding content from Facebook and social media? So if someone else shares it and it somehow doesn't get deleted, then that license continues. So it's really very interesting to see what these social media, what it really means, you know, when you sign up. Go ahead, question. Okay. Yeah, so the question was about sub-licensable and what that really means. But yeah, it's very generic. You know, what that term means, you know, they could sub-license it to anyone they want based off of the reading of what the terms of service says. You know, so, you know, it's either a business opportunity or it's mostly for limited liability purposes for Facebook, just if they potentially do it in the future. You know, but it's really, really fascinating to see what these terms are. Another question. Okay, so the question was, do you lose out on profiting? Yeah, so when they sub-license it, yeah. I mean, these terms in here means that you don't get any of the money because they're sub-licensing it to someone else. But it doesn't mean that they own the copyright. They don't own the copyright. You own the copyright to all the work. You know, this is just what it grants them. And we'll have a couple more questions, and then I'm going to be outside asking any more, to come up to me with any more questions. No, you could still give it, you could still grant and give a license to someone else, but this is just another license that you're giving out to someone. So someone else, you could license the same content that you put on social media to someone else, either a photo agency or to a magazine, you're granting them, but this is just giving someone, Facebook or the particular social media, permission to license it. Go ahead. Well, you know, no, I mean, yeah, you can't license it exclusively, but you could do it non-exclusively because technically you're giving them a license. So, you know, obviously, you know, be careful, obviously, what you post. I know someone question down over there. Go ahead.
Yeah, I guess I have a question because so many times we're using this to really stimulate business for ourselves, right? We're using it to get the word out about our artwork. So what is the best way to prevent, you know, I guess flashing copyright on it? They can remove that, right? You know, if they steal the image, if maybe posted something extremely low resolution, which they wouldn't do much of. I mean, what is the best way around this
Yeah.
dilemma?
That's a good question. So the question was how to protect yourself when you put something on social media, you know, because it's so easy pretty much to steal, and what to do. So what I do recommend is, you know, putting a watermark on the photograph so that, you know, if someone does steal from social media, that your name is on there and they could easily contact you through the private messaging or just, you know, email you directly. You know, if you put on the caption of the photograph, you know, do not use without prior permission, or no one else could use it, contact me for a license. That's a tool because it puts whoever's on notice that, hey, it's your content, and if they steal, then it shows willfulness. It shows, you know, that if it's registered timely and you're eligible for statutory damages, that you can get the $150,000 per work, which is very, very significant. So those are some of the ways that you could, you know, protect yourself, because, you know, you want to use social media as a business tool, right? You want to showcase your work, you know, put it on social media and get a lot of likes to get people to come to your website, but you also want to protect it at the same time. So I recommend that you make sure that your stuff is registered with the Copyright Office, you know, within the 3 months of first publication, whether that's within 3 months of when you first posted on Facebook or Twitter or Instagram, so that if someone infringes upon it, your remedy is $150,000 per image. So you could showcase your work, get it out there, and if someone infringes, you could say, here it is, here's the copyright registration, and you want to make sure that all your images are registered and registered timely, and make sure that everything's lined up with the correct date, because the defendant is going to try to poke holes in the registration to say, oh, it's incorrect, the registration's not right. So it's very important that you go through that. Okay, so I'll be outside with any other further questions. I want to thank everyone for being here today, and it's a really great time. Thank you very much.